Great. Thank you. So our final submitter for the day is Kiwi Fresh Orange Company Limited. Mr. Duisberg, I understand. We're ready to hand over to you to present your submission in a minute.
Thank you, sir, and good morning, Commissioners. As Chair said, my name is Mike Duisberg, solicitor for the Kiwi Fresh Orange Company, and with me is my friend Mr. Musson, who will be presenting part of the submissions to you today. Before we get on to the written submissions, two preliminary points. We apprehend that given the site-specific nature of the rezoning submission in this case, that it might be good for the panel to do a site visit onto the property.
Oh, yes, so we're planning to do that on Thursday. Yeah. So, yes, I was going to talk about that now, if you like. So, we think we need to spend, quite a bit of time understanding the property, and it's quite a large area of land. We have viewed it from State Highway 10 and some of the streets that lanes that come off Kerikeri Road. But we haven't been on the property, we haven't been to the golf course property. We're going to go to the golf course as well. But if you would like to facilitate our access on Thursday and have someone show us around, I think we'd be assisted.
We can certainly arrange that to someone to point out the key features on the ground. And a related point, or on the point of the site visit, Mr. Brown and Mr. Corbett have suggested to me that actually one of the best ways to understand the context of the site and appreciate its connection and proximity to Kerikeri-Waipapa and the Rainbow Falls is actually to view the site from the air. And so if the panel would be interested, we could look to arrange a helicopter, and it's comfortable doing so, we could look to arrange a helicopter viewing of the site, the golf club, from the air as well. I'm not sure if that could be arranged for Thursday, we can make inquiries, but and you don't need to give me an answer right now, obviously, but that's something that is a...
I did bring my hiking boots, but I don't think we would object to it, because I think it possibly could be quite helpful. We'd probably want to get boots on the ground though.
Yes, and we would suggest you do both. If you are going to take up that offer, we would do both.
Okay, well, I'll leave it in your hands to see if you can arrange that. We have to visit a number of other properties. There are other submitters that have land seeking rezoning as part of the spatial plan area. So we thought we would get those done in the morning. Yes. Or at least in the late morning, and then we would probably be in your hands at that point. So we probably still would want to go to the golf course. So perhaps if you can get in touch with Alicia Kate on that, we can arrange something. We have arranged accommodation for Thursday night, so we have a whole day available to us if we need it.
Okay. Thank you. Well, we'll see what we can organise. Excellent. The other preliminary matter I wanted to just address briefly is with the way this evidence exchange process has happened in reverse. We've had the submitter's evidence first, council response. Yes. Submit a reply. The council has then filed a summary statement, which is also a rebuttal in its nature. And I understand from reading those statements and some of the comments at the hearing yesterday that the intention is to do a further reply following the hearing to respond to anything that's raised to submitters. And I understand how this process has come about. I understand where it's come from, but my client is concerned that if aside from the council having had a number of bites at the cherry, if new material comes up in that reply, anything that's fresh, we'd be concerned that we wouldn't have an opportunity to respond to it. I'm not looking to leave now to file a further reply or further rebuttal, but I just want to signal that if we apprehend anything that comes in fresh in the final reply that we haven't had an opportunity to respond to, that is new, that is genuinely new, we may seek leave to file a brief response to it.
Well, we take the same approach. Council, we've been allowing council to reply to evidence on hearing one, and our experience to date is that they've stuck to that and haven't introduced anything new. And so they'll be they will be abiding by the same principles.
Excellent.
Yeah, so thanks for raising that issue, but I think you can be rest assured that we're going to be as vigilant as well.
Thank you. Thank you, sir. So to the submissions, we pre-filed these. I think they unfortunately were not Saturday, but have you had a chance to?
I was going to say, there's been a lot of material.
Yes.
Particularly well, this hearing, there is an immense amount of material.
It's always the way, isn't it?
The 42As are very comprehensive and there's lots of council memorandums and evidence. KFO itself could have justified its own hearing. We set these hearings like well over a year ago, and then we initially only allowed 1 week for all rezoning hearings. We then split it into 4 hearings, but we're still really sort of doing a lot of it. Really, to cut to the chase, we've only had a brief look at legal submissions because we were really scurrying to catch up on other material as well. So we've got the rest of the day.
Yes.
So would be helpful if you take us through here. I'm happy to read every word if you want to, or skip the bits that you can take as read. Because I think, your legal submissions will probably be quite important. We gave the council quite a lot of leave yesterday with their legal submissions. So we'd like to offer you as much time as you need to get through your submissions as well.
Thank you, sir, for that indication. What we will do, I think, is we will work through it. There are some points that are less important or are more in the nature of a summary, which we may briefly skip over, but we'll spend the time to take you through the important points rather than assuming that you've read it all. And as I indicated earlier, I will take you through, I'm just on page 2 of the table of contents, I'll take you through the introduction PEP process. My friend will address you on the preliminary issues, which is predominantly where we deal with the kind of key cases, key immunities, and then I'll deal with part 4 and the conclusion. Very well, let's begin. Paragraph 1, we're here for Kiwi Fresh Orange Company, KFO, as everyone, we do love an acronym in this space, don't we?
Oh, one more thing.
Yes.
Obviously, you're happy for us to refer to your client's KFO?
Yeah, yes, yep.
And I'm thinking, we sort of agreed yesterday that we refer to the Kerikeri-Waipapa Spatial Plan as the Spatial Plan.
Yes, and we've used the same definitions, but yes, that's excellent. So yes, KFO seeks rezoning of its land from rural production under the PDP to a mix of zoning, master plan. This hearing is extensively about the appropriate zoning pattern and provisions for Kerikeri and Waipapa and what is the most appropriate to Section 32, that's our ultimate guiding test. But in reality, this hearing is about the future of Kerikeri and Waipapa. Decisions on the PDP will directly affect the current and future communities of this area. At the core of its proposal, KFO is seeking to enable its site to be developed by housing supply in an area with significant current and predicted housing affordability issues. That development is to be integrated with appropriate retail and commercial development, and it's to be delivered in a way that responds to the particular features of the site and its surrounds. The proposal responds to current and future demand for housing, and you don't need me to remind you, you've just mentioned it, sir, it was an issue that we identified as early as hearing 1. The council initially didn't accept that proposition, that the council is a tier 3 local authority and that Kerikeri-Waipapa is an urban area, but that has now been accepted. Importantly, the KFO site presents an opportunity to provide affordable detached housing, which meets the core demand of the community. The benefit of the proposal of providing affordable housing doesn't appear to be contested, and I refer there to comments in the 42A report and in Mr. McCourt's evidence that seems to me accepts that the KFO site has the opportunity to provide affordable housing. This proposal is not opportunistic spot zoning. It has been developed over many years with detailed expert assessment and close engagement with the local community. The proposal has assessed the site's constraints and responded to them. Hazard risks, highly productive land, ecological values, transportation effects have all been carefully assessed. Infrastructure issues have been considered and feasible solutions are available. Urban design and planning matters have been evaluated and appropriate provisions drafted. In terms of the legal test, we submit that the proposal gives effect to the NPSUD, gives effect to the regional policy statement. It's the most appropriate way to achieve the objectives of the PDP and that there is evidence in support of it that has had regard to the actual potential effects that the proposal would have on the environment. The reporting officers recommend that the proposal be rejected, and the core basis really is that the council has advocated the rezoning proposal that's described as the PDPR, and just to check with you, sir, you're happy with that? When we refer to the PDPR, we mean the rezoning proposal in the full form.
Yeah, no, I think council's comments yesterday referred to PDPR, so we'll adopt the same terminology.
Excellent. So in addition to advocating for that alternative rezoning, the reporting officers also argue that further information should be provided on certain matters in relation to the KFO proposal. First, we say that the PDPR is a flawed proposal, respectfully. It fails to deliver housing of the quality and type demanded by the market, attached dwellings, and most importantly, it fails to deliver affordable housing. It is concerning that the PDPR seems to rely on other housing typologies being unaffordable, so that the community will be pushed or will be driven to accept denser typologies of attached dwellings and apartments. And we say it's not the role of the PDP to force the community's behaviour in terms of housing choice, nor is that an outcome that is prescribed by the objectives and policies of high-level documents. And just on this point, in terms of what the high-level documents are directing us to do, I will address this through the submissions where it comes up, but a point I heard a number of times through the presentation from the Section 42A reporting officers, notably the planners, but also urban design and the economic evidence, is that the spatial plan is directing an intensification outcome, and that this plan needs to respond to the spatial plan's intensification directive. There's a significant problem with that proposition. The spatial plan is a non-RMA document that was promulgated through a separate council process without the full rigour of a Section 32 assessment. The spatial plan is a matter that must be had regard to in terms of the hierarchy of the RMA. When you talk about what that test means, it's always a nice little bone of contention, and you did talk about it with Mr. Fisher yesterday. It is not in the nature of higher order policy statement, like the National Policy Statement for Urban Development, like the RPS, or like the objectives of the PDP. That is the policy direction that you are guided by, and you need to give effect to, or you need to assess whether the proposals are the most appropriate way to achieve the outcomes. To have regard, or to elevate an outcome prescribed by a separate non-RMA process that began after the PDP started, and to constrain your decision making to achieving that outcome, I think would be an error of law. Returning to paragraph 8b, we say that the PDPR is based on an incomplete effects assessment, and ironically, despite criticism about the level of detail delivered by KFO in its effects assessment, the reporting officers have provided no assessment of key potential environmental effects of the PDPR, and the most notable example is the traffic effects of that proposal. And we say at C that the PDPR will affect people in a way that they did not anticipate and without adequate consultation. The PDPR rezones private land without consultation, and it will affect both those landowners and the landowners that adjoin that area, and that there is real risk in my submission of significant prejudice if it is confirmed. You'll hear about the spatial plan, and I have just spoken to you about that in a little bit of detail, and the key point from paragraph 9 is we say that it is a relevant consideration, you may have regard to it, but it should be given little weight, both in terms of what we say are flaws in its process, but also generally as a spatial plan is less important than being guided by the policy documents that you must be guided by under the RMA. But it is notable that the KFO site is included in the spatial plan as a contingent future growth area. We encourage you to carefully scrutinise the evidence before you, and in our submission, when you do so, we say that the zoning pattern and provisions proposed by KFO are the most appropriate. We're now at paragraph 11, and I won't read paragraph 11 to you in detail, but it really just identifies it names the site at the end and identifies that the zoning that's proposed is general residential, mixed use and natural open space zone. The relief at paragraph 12 is to apply those zones, and it's to impose a precinct as contained in this O'Connor's rebuttal evidence. And we do still seek consequential changes to the general residential zone as outlined in the submission, but no longer is KFO pursuing changes to the flood hazard overlay. The original submission sought to reduce the overlay as notified to only apply to the proposed flood spillway. That relief isn't being pursued. Instead, the precinct provisions have been designed to provide that the flood overlay continues to take effect, and after the flood spillway has been designed and integrated, development can be enabled in areas that were previously covered by the flood hazard overlay. And so it deals with it in that way rather than now trying to reduce the scope of that overlay area. The proposal doesn't seek to reinvent the wheel. It operates as any precinct does. The underlying zoning provisions, as well as all of the district-wide provisions of the plan, continue to apply, and the precinct provides additional controls on core matters that it needs to respond to. And so, that's an important feature of the proposal that shouldn't be overlooked. At 14, we really just emphasise that point, that the natural hazards chapter of the plan will apply to any proposal within the flood hazard overlay, and that other controls related to ecosystems, indigenous biodiversity, agriculture, landscape, public access, and of course subdivision continue to apply as they do to any land of those zones. So I think I've generally described the content of 15 to 17 to you. I won't take you through that in detail. The precinct provisions have been designed in a way that reflects, at least historically, what has been a common tool to enable careful and comprehensive master plan development, which is the preparation of a comprehensive development plan. There was a small period of time after 2009 where we thought that was naughty and we weren't allowed to do it, but subsequent cases have confirmed that a CDP approach is indeed lawful. The precinct provisions require that a comprehensive development plan is required as part of the first resource consent application for subdivision use or development within the precinct. Now, Ms. Rennie, I think, has commented, is a CDP actually required by the provision? The way the provisions are structured is that it is a restricted discretionary activity to provide, to apply for and develop the CDP as part of the first development. If you fail to do that as part of the first development, it's a discretionary activity. And the reality is that applying the precinct provision sensibly, the question from council in processing that application as well, where are all of the things that the CDP is supposed to do? If you're not providing it, please assess what these matters. We don't think there's a gap. The first development is either going to come out of the CDP as a restricted discretionary activity or comes as a fully discretionary activity, enabling full assessment of all of the effects and all of the relevant policy documents. The CDP deals with matters of detailed design related to layout, location, staging, road connections, funding, delivery of infrastructure, stormwater hazard management, and so on. The intention is that the CDP addresses the entire site, but it can be implemented by subsequent subdivision development in stages, as in the subsequent development can come in stages. And it's designed to secure the outcomes contemplated and provided for file structure plan. And just on terminology, actually, there were some questions about this yesterday.
Yes, thank you.
Yeah, the structure plan describes the process that was undertaken in formulating the submission and the documentation that was provided with the submission, which set the context and the response to key issues. So that's the larger document produced by Ms. O'Connor and Mr. Neal that accompanied the submission. That's what we describe as the spatial plan. That's the assessment and the analysis. That has led to the development of the precinct plan, which identifies the proposed zoning pattern, indicative access location, and matters of that nature. And then the CDP, the Comprehensive Development Plan, is a process to come by which resource consents will deliver detailed design and will be assessed fully by the council, and the development will be implemented in accordance with. So I appreciate that there possibly will be examples in the evidence where the terminology might not have been used accurately in all cases, and we do apologise for that. It's often a way we get comprehensive evidence like this. There's a structured plan that's meant to be a precinct plan through, but that's the intended distinction. Spatial plan was the high level, structured plan was the high level word. Precinct plan is what's attached to the provisions that intends to bring that into the planning framework, and then the comprehensive development plan is the subsequent detailed designs adopting that normal type of process.
You know, that's helpful, thank you for me. And I guess the CDP would be quite a lengthy document in itself. It'd be similar to the structure plan type document.
Certainly, it will be a full resource consent application, AEE, that full package, and then there will be at least the CDP resource consents with a number of conditions, management plans, and a detailed plan addressing core issues such as urban design, that kind of thing, all built into a resource consent framework.
And the structure plan, is that something that the criteria that are proposed in the precinct would refer back to? Or is the structure plan sort of history?
Well, the structure plan was admittedly, you talk to us in more detail, perhaps better than I can, but the structure plan was developed to inform the rezoning proposal, and the intention is that the key elements have been brought through into the provisions, into the assessment criteria, particularly into the objectives and policies that have been formed with the precinct plan.
Okay. Thank you.
Okay, 19, evidence. We have filed comprehensive evidence, or KFO has, and there are the witnesses, and that's our intended order to call them today. Mr. Brown and Mr. Corbett are here with us. Mr. Thompson is here somewhere. There it is. Mr. Hunt will be joining us as well. Mr. Kuta will be online, as will Ms. Barnett, Mr. Ehlers, Mr. Brown, and Mr. Hughes. And then you have Mr. Neal here as well. I think you've already seen him today, and the same with Ms. O'Connor. Just touching on primary issues, I'm not going to lecture you about Section 32. You've all been on plenty of planning cases before, and you've been sitting on this one for a while. What we've done is in our Appendix A to our submissions, to assist you if it is helpful, is we've taken the rezoning criteria that you released in your minute 14, and we've provided a bit of a roadmap where we say in the evidence in chief those key matters are addressed. Sure, you'll be looking back at evidence in your deliberations, and I don't want to take you through that, but in the event it's helpful, that's where we say a number of core issues are addressed in terms of that evidence chief. In my submission at 22, the key issue really for this hearing how does the PDP give effect to the National Policy Statement for Urban Development as it relates to options for zoning, housing, business land in Kerikeri-Waipapa? Does the proposal meet the exception in the NPS in section 3.6 of the NPS HPL? And then the nice, easy one that's not difficult at all, but what's the most appropriate way to achieve the objectives of the PDP? In terms of reasonably practical options before you, and I think this is quite an important point, the section 40 has identified that there are essentially three options for Kerikeri-Waipapa. The first is the PDPR, It's the 42A reporting officer's recommendation. The second is to rezone KFO site, and the third is a combination or a hybrid. And we agree. There are not sufficient other rezoning proposals that will provide the housing capacity that is required as identified by the HBA and by Mr. McElraith's subsequent work. These are the options that will deliver that demand that you are required to deliver. And yesterday you had some engagement with my friend Mr. Fisher about how the PSUD applies to you, given that in terms of the directive obligations, Tier 3 authorities are only really required to remove transport provisions. I agree with my submission my friend gave to you. You are still required to give effect to the objectives and policies of that document, and that does require you to do the things that those objectives and policies require when formulating this plan. So you'll be pleased to know that's not a legal issue you need to resolve between the two of us.
That's good to hear.
That's one anyway. So at 24, where KFO differs from the Section 42A report is that it says that the PDPR scenario will not provide housing of a quality, price or typology. We'll develop this thing further, but we say just having the numbers of demand line up with the numbers of capacity is not the end of the story. We say a more granular assessment is required as to the typology, quality, and price of housing. And I mean, to put it bluntly, and I'm not suggesting that this is what the council is doing, but identifying that there is housing demand and then proposing to meet it with $4,000 mansions that no one can afford and no one will be able to live in just doesn't do what the PSUD requires. That would be a no-no. And we say that actually, when you interrogate it, what is being proposed by the PDPR is a similar effect. I say at 25, an initially important point, and I don't think you would make this mistake, but when reading the 42A report, you could take it that the PDPR is intended as the status quo, or that's the presumptive approach, and any submission that differs from it is what needs to be justified, and that's not correct. The PDPR is a starting point. The PDPR is simply a submission that 42A reporting officers are recommending it be adopted. It needs to be subject to the same rigour under Section 32 as any other submission would be. Go at 26. This is another important small point. The Section 42A report and some of the evidence in support assesses submissions by comparison to scenarios D and E of the spatial plan. And I think, for example, Mr. Hensley's infrastructure evidence, for example, does this, as does some of the other evidence. No person has made a submission on this plan seeking that the spatial plan be implemented. Certainly no submission seeking that scenarios D and E be implemented. And unlike other recent planning processes, like the process to implement the medium density residential zone that we all went through rather painfully recently, or the Auckland Unitary Plan, the normal Schedule 1 process does not empower you to make changes that you think are a good idea but haven't been sought in submissions. You are constrained by what, and I think my friend fairly summarised this yesterday, you're constrained by what's been fairly and recently raised in submissions. So we say D and E aren't on the table and they're not relevant considerations for you in your assessment. Similarly, the council's suggestion that its intention is in the long term to implement the spatial plan by promulgating future plan changes to achieve scenarios D and E isn't a matter that you can place really any weight on, certainly not significant weight on. The council can't bind a future council to promulgate a plan change, and certainly in the short term, the council can't do any planning at all, not before 2027, and then I dare say it, we're faced with RM reform and who knows what's going to happen after that. But the point to you is the suggestion that medium and long-term problems will be solved by a forthcoming plan change is not a matter that can have any comfort that that plan change will ever eventuate. All it takes is a change of council, an election coming up, or or a decision to not promulgate a plan change, and that won't happen. And I think you can look to the past to see whether that will happen in the future. The ODP became operative in 2009. It's been what? It was 15 years, 14 years before the next plan was promulgated, despite the obligation to promulgate a review after 10. It just reveals that planning, despite best intentions, it just never really keeps up with what may be needed.
Can I just ask a question about your paragraph 26? So are you basically saying that the spatial plan, even though it's out there and it's showing, areas of future residential growth, let's say, coming down the road here, we shouldn't, engage with that because there's no scope to do so, and it's something that a future plan change needs to deal with?
It's a good question. I think my point is perhaps a little finer than that. It's you may have regard to the spatial plan in terms of showing what it shows and being valued for what it is, and I'll tell you what I think about it honestly shortly. But to the extent that to form a conclusion that there is sufficient capacity either in the medium or the long term because there's a process to come to implement the spatial plan, I don't think you can have any comfort that that process will come or that it will implement the spatial plan. And that's because it relies on a decision under Schedule 1 to promulgate a plan change. It can't happen before 2027, and we don't know if it will happen after that.
Yeah, thank you.
So, in terms of the parties' positions, and I'm going to talk a little bit more about the NPSUD in this section, but the position of the council is a sort of council officers is essentially that the PDPR provides sufficient growth, short and medium term, with opportunities for attached typologies and then attached in the long term. And they say that you've got the spatial plan, don't worry about it for the long term. Mr. Waite's report essentially says that the PDPR provides sufficient development capacity, and that KFO's proposal doesn't meet the sufficiency test under the NPS-HPL for that reason. And he says it's not necessary to give effect to policy 2 of the NPSUD. There are technical grounds for opposition as well, which we'll deal with under Part 4. But the essence of the reporting officer's case, as far as I can define it, is that while, and I've set out a quote here, and I've bolded what I think are the key bits, but while the KFO proposal will give effect to provisions relating to competitive land markets and providing sufficient development, the economic evidence demonstrates that the PDPR also gives effect to those requirements, overzoning is expected to undermine the effectiveness of the PDPR to enable intensification. I'm going to talk to you about what I think about that shortly, my submissions on that shortly, and it will reduce the benefits associated with contract growth. It will not contribute, KFOs will not contribute to a functioning urban environment. So, unpacking that, the position seems to be that the KFO proposal is unnecessary because the PDPR already provides you with everything you need and gives effect to the NPSUD, that there would be adverse economic effects associated with oversupplying greenfield land, but actually when I look at that more after having written these submissions, it's more that there will be that the KFO proposal will detract from achieving the intensification directive that the council feels it's bound by. And that's what I say at C, that it will providing sufficient greenfield land will not achieve the intensification, and therefore the KFO proposal doesn't contribute to a well-functioning urban environment. Putting it more simply, Mr. Waite accepts that the KFO proposal will give effect to the NPSUD in terms of providing housing at lower price points, but he considers that it would undermine this uptake of intensification under the PPR. And I think when you step back from it, it's actually quite an astonishing position to take. The reporting officer position is, rather than that, providing sufficient greenfield land to enable more affordable housing, supply should be constrained so that people are forced, in order to be able to afford housing, to choose attached typologies. The vision that the reporting officers are seeking is that you impose on the community density and intensification, predominantly townhouses and apartments. That's how the medium and long-term growth is proposed to be solved by the PDPR. Respectfully, it's a social experiment to make housing in Kerikeri-Waipapa of the type that all experts agree are demanded. Mr. Micklewraith says 90% of demand is for detached dwellings. Mr. Thompson, I think, says 85%. But that's by far the vast majority of demand is for detached typologies. Those typologies are not affordable under the PDPR. They start at, I think it's $1.26 million today, and they climb to $1.6 million for detached housing in 2035. And because those dwellings will be unaffordable, we will see a shift towards people buying detached houses or apartments, and that's how we satisfy long-term growth, is by pushing people into those typologies. My submission is that that's not what the NPSUD is asking of you in terms of achieving well-functioning urban environments, particularly given that the NPSUD itself is seeking to drive competition and to ensure that there is housing choice in terms of various matters, including, importantly, price. So at 36, I expand on this and I say that the NPSUD does not demand intensification of Tier 3 local authorities. I think the NPSUD itself doesn't set an intensification directive. It sets a well-functioning urban environments directive. Only Tier 1 and 2 authorities have a specific intensification directive in terms of upzoning near, transport, that kind of thing. The same does not apply to Tier 3 authorities. And I say at the end of that subparagraph A, the well-functioning urban environment is one that meets the needs in terms of type, price, and location of different households. And that's policy one of the NPSUD. At B, I say that the PDP does not set an intensification directive. The closest I've been able to find, having reviewed the strategic directions and the other provisions of the PDP, having regard to the 42A reply version of all those documents, is strategic directive objective UFD2, objective 2, and that's the one that seeks to consolidate urban development and to achieve a compact urban form. My submission is that that's not the same as the intensification imperative that is being pushed through the PDPR. Development in Far North and indeed Kerikeri-Waipapa has been characterised in the past by rural residential sprawl with on-site servicing, and so achieving, in my submission, detached dwellings on standard residential sites would include achieve that objective too, in terms of consolidation and compact urban form. We have looked at the Section 32 analysis for the strategic direction chapter, and there's nothing in that suggests that there's an intensification period hiding behind objective 2. The aim of that objective is consolidation, avoidance of sprawl, and efficient infrastructure provision. A short quote here at page 9. A short quote here from page 9 of 32. The submission is that objective 2 is a means of enabling more development in and around Kerikeri-Waipapa and other centres, and it's a means of avoiding that rural residential sprawl that has been prevalent in the market historically. And again, really just emphasising the point, Section 42A report on that objective, dealing with a submission that was suggesting that instead of consolidation, we should say intensification, and rejecting that submission, said that, that intensification may be a subset of consolidation, but that's not what's intended. So in my submission, intensification at any cost is not an end that either the NPSUD or the PDP is pursuing, particularly where it impedes other aspects of strategic direction, principle and affordability. And I've said to you earlier, the spatial plan is not an appropriate source to take an intensification directive from. I won't repeat that for you now. TAFO's evidence will demonstrate that consolidation supporting compact urban form affordability and providing a mix of typologies will be achieved by the TAFO proposal, and it will help reduce the pressure for rural residential development that the PDP scenario risks perpetuating. And by that, I'm referring to Mr. Thompson's evidence, which does the wise thing at looking at history to try and understand what might happen in the future. The operative district plan has enabled more intensive development than we've historically seen. I think Mr. Thompson and Ms. O'Connor addressed that. The ODP would enable townhouse development of 3 townhouses on 600 square metre sites, but there has been zero market uptake of those typologies. There have been 2 developments that I think you're aware of. First is the Habitat for Humanity development just down the road here of 2-story attached dwellings, but not an on-market delivery, an off-market for social housing delivery. And then we have the climate law development strict. Again, climate law is not the private market has delivered none of these typologies historically, despite being able to. But yeah, instead of, I think Mr. Thompson.
You might need to raise your voice.
Yeah,
right?
Yeah,
Please.
Mr. Thompson addresses the trends in that historic development. If I recall correctly, I think it's 4% of development historically, and since 2010, has been infill development, and 59% has been rural residential subdivision. And so my submission to you is that there is a very real risk that if we push for an intensification imperative, despite the plans and policy statements not actually requiring it, if we're going to drive other detached housing choices to be unaffordable, we will just continue to see support of rural residential development. Just finishing that paragraph with H. The NPSUD strives for a well-functioning urban environment to meet the needs of the community, and so does Strategic Direction Objective 1, which puts the well-being of the people who live in and visit the towns and the farm first. What makes a well-functioning urban environment and puts the well-being of people first is context dependent. While intensification might be desirable and makes it difficult,
I noticed from the fact that we have people listening online, they'll probably be struggling. I don't know if anybody over here.
They have to confirm that it's fine online.
Okay. Should we take 5 minutes to see some pass it over?
Yeah. How do you think sound quality is? I think we've things have relaxed a bit, haven't we?
It does sound like it has, and I can try and talk a little louder.
Yeah, okay. Well, I don't want to give you narrow drivers, so.
No, that's okay.
So just look, if it gets heavy again, just feel free to pause.
Okay, thank you, sir.
I think we were somewhere in paragraph 36.
Yes, that's right.
Some of the
So I was finishing the date, I think.
Yeah.
Yeah. What we're saying is that the NPSUD, by its very nature of being national policy direction, its implementation must be context dependent, depending on the particular district or regional circumstances. What is a quality built environment or a well-functioning urban environment in Kingsland, Auckland will be very different to what is a well-functioning urban environment up here. You know, we say that it's not desirable to plan for Kerikeri to be the same as Kingsland, Auckland. Certainly not 15 stories Kingsland, Auckland. And particularly where you have evidence, including through the spatial plan and reflected in the spatial plan, of the community wanting to maintain Kerikeri's village feel while also having affordable housing. At 37, I make the point again that the evidence demonstrates an overwhelming market preference for detached dwellings, and it's supported by Mr. McGrath and Mr. Thompson's economic work, as well as Mr. Corbett's on-the-ground real estate experience. And again, at the end of that paragraph, making the point that no market terraces or apartments have been delivered, despite that being enabled since at least 2009, and possibly slightly earlier once those provisions were legal effect. So at 38, we say that the PDPR scenario is misaligned with demand fundamentally, and that the result is a theoretical sufficiency, and that is unlikely to be realised in practice, which risks perpetuating unaffordability and rural residential development. We say that KFO's proposal provides a prudent low-risk pathway that ensures that Kerikeri-Waipapa are not left exposed to the risk of the overly optimistic assumptions that support the PDPR. Mr. Thompson has addressed in his evidence the risks and the costs and benefits of over and under supplying land, and we say that that evidence can be relied on by the panel in assessing under Section 32 the risk of acting and not acting. That's an assessment you need to make if there is uncertainty in relation to a matter. You need to consider whether there's a risk of acting or not acting. And we say that the evidence about the cost of principally undersupply is very relevant to this as well. At 40, I emphasise that KFO has assessed the various expert topics, but I'm going to say that a bunch of other times, so I won't repeat it here. The NPSUD at 41 doesn't require the panel to choose between intensification and greenfield development as mutually exclusive outcomes. Unlike the reporting officer who's ruled out the KFO scenario or the hybrid scenario, we submit that it is open to you to adopt a hybrid approach if you are minded to do so. And you could enable both infill and greenfield capacity, provided that you're satisfied that the minimum statutory tests are met. And if you are minded to go down that pathway, KFO is certainly available and willing to engage with the council to address any matters that you think would need to be dealt with, including by way of expert conference and help. So, part 2, and I probably will step through this section a little bit promptly, but this section addresses some concerns we have with the PDPR and how it's come about and with the spatial plan. KFO has maintained a consistent position throughout the PDPR that its proposal is needed in order to achieve the NPSUD. Instead of rezoning new greenfield land to provide development capacity, the PDP instead, as notified, consolidated residential zones into a single general residential zone, the position was that at the time that the Kerikeri-Waipapa area was not an urban environment. Sorry, I might just skip through some of this because this is mostly history that you'll be familiar with in terms of the development of the PDP through to Area 1 and the council now accepting that. Now accepting that Kerikeri-Waipapa is a urban environment. Okay, so at 47, separately and after the promulgation of the PDP, the Council reignited development of the spatial plan, and then adopted a hybrid of scenarios, what were called, if you're familiar with it, D and E. So growth predominantly south of Kerikeri, so a small amount of growth at Waipapa and intensification in the Kerikeri town centre. And so that was a combination of greenfield development and infill intensification. An HBA was prepared, although, as you quite rightly pointed out, the council had no obligation to do so. It has produced an HBA, and it found that there was a shortage of capacity for detached dwellings in the short term for Kerikeri-Waipapa, worsening into the long term. And the council's position through the spatial plan was that that would be solved by providing a mix of greenfield development and infill, with a very small proportion, 5% of rural residential development. And we're referring to Mr. Thompson's evidence, and those numbers are drawn from the spatial plan documents. The spatial plan's confirmation presented a problem. The PDP had no scope for rezoning aspects of the spatial plan that were to be implemented, and so in response we had the PDPR proposal. As you'll be well aware, the PDPR first came to light as part of hearing 14, at least as far as my tracking of it goes, where Ms. Trinder reported and proposed that as part of that hearing topic, that modified versions of Kerikeri-Waipapa in medium density residential zone and town centre zones would be adopted. I think at that time, both the provisions and the spatial extent was TBC until these hearings. And at that hearing, that's where the council formally recognised that Kerikeri-Waipapa was an urban environment. The spatial extent crystallised in August in the section called Rail. And so this is where I'm really addressing what I think is a potential fairness issue. The Kainga-Ora submission for the report, Kainga-Ora submission technically provides scope for the PDPR. We're not saying that it doesn't, but there is a wider process concern here. Kainga-Ora hasn't given evidence in support of the submission. Instead, the 42A reports officers have engaged their own experts to provide technical evidence. And so it's not the council's proposal, it's not KO's proposal, it's the reporting officer's proposal. This does create, in my submission, issues for the community. KFO submits that there is a conceptual difference between a submitted proposal pursuing a rezone proposal and to upzone Kerikeri, supporting with evidence that it being accepted by the council, and the council notifying a proposed plan which upzoned Kerikeri, proposed upzoned Kerikeri from the start. The latter scenario would have put people on notice that that was the proposal and would have naturally garnered significant public interest, particularly from those people whose land was proposed to be rezoned or who lived directly adjoining it. Mr. Corbett, in his evidence, and you can speak to him about this today, he's been in the community, he's a long-time resident, he's been speaking to people, and he can tell you about the number of people that he's spoken to that were just unaware of the PDPR entirely. The evidence that has been filed in support of the PDPR is limited, and so from topic 14 through to 15B, really the core evidence addressing issues and effects from the PDPR are the urban design evidence from Ms. Rennie, Mr. McRae's economic evidence, Mr. Lindenberg's NPSUD policy assessment, Mr. Hensley briefly on infrastructure, and Dr. Hill, I think, just with a couple of paragraphs saying that it's urban, so we're not going to affect rural productivity. Really importantly, and quite surprisingly, given the significance of the criticism from the council's transport engineer, no modelling has been done from what we can understand, and certainly not provided in relation to the effects of the PDPR on the transport network. We say that there's also limited evidence about the existing infrastructure for wastewater and water servicing. My understanding of Mr. Hensley's evidence is that there is some capacity now, and there's a future work program that's recently been confirmed, but I haven't seen the details of that future work program and actually what projects are planned and funded. And quite importantly, there's no evidence of consultation and engagement with the community or with my firma. And I don't say that just to try and make a point. Consultation and engagement was a specific criteria identified in the Minute 14 rezoning matters. KFO submits that there is real risk that persons that are potentially affected by the PDPR have been denied an effective opportunity to participate in this planning process. And we reiterate our earlier concern that the reported officers appear to be advancing it as a default position that other parties need to advance. And again, I know that's not the case. At 53, in terms of substantive flags, we...
Can I just interrupt for a moment? Because I'm just going to leave this to the end, but I'm just wondering if we could just explore it more. About the scope, please.
Yeah, please.
Do you know the difference between greenfield areas notified in the plan, originally residential zone, new residential zones? The difference between what was notified in the Kerikeri-Waipapa area and what the spatial plan identifies for new greenfield areas?
Yes.
Yeah. So are you able to enlighten us as to what those differences potentially are?
Well, so
I suppose what we're interested in, what new greenfield areas were notified?
Were between the ODP and the PDP.
Correct.
Okay. Well, I mean, that is a matter that I might need to ask you.
Yeah, and I'm happy to telegraph it now and be addressed later.
Yes.
And I'm telegraphing it to council officers too, so everyone understands what we're interested in getting.
So we will get you that information, and I think it will be a relatively simple task of comparing the notified planning maps with the ODP maps, but I'm afraid I don't have that.
Yeah, because I mean, your legal submissions are saying things like intensification has been sought as almost like the only way to achieve urban growth. But what we're interested in is how much greenfield land was notified with the plan. And obviously, it's still an open question as to whether it is a scope question or not. We certainly would like to know where we're headed if it is. The other question is, again, with regards to scope, is, and this is it's quite a legal question, scope. I mean, the Kaioora submission was quite specific and quite detailed, and they even set out the areas. So everyone got to see that submission. So, but with regards to the scope of any new greenfield areas being rezoned, are you aware of any submissions that generally sought land to be rezoned residential around Kerikeri-Waipapa?
Is it a general rezoning or land? No, we've done that analysis. We've looked at the scope of submissions quite carefully to understand, so that I could make the submission to you that there is not another reasonably practical option. There are a number of small, discrete rezoning requests. I think most of them.
We heard a number of those tomorrow, and yes, sorry, tomorrow, yesterday.
Yes.
And there are quite a few, and sizable areas of land, and there are obviously things that we could have regard to.
Certainly they are, but I think the reality, I think, the reality is that it's not enough. At least my understanding, it's not enough to meet the demand that has been modeled on whoever's calculations are used.
Yeah, so I think where we're interested is that if the scope issue is something that we need to make a recommendation on, whether there are other submissions that could potentially be relied on. And so I think your legal submission is you've done the analysis and you don't think that there are any sort of general nature submissions seeking residential zoning in rural areas or non-urban areas.
That's right.
Yeah, they're all site specific.
And relatively discrete, and a number of them, a number of them are either in locations that will not solve the issue or will not be able to provide sufficient capacity to solve the issue. Yeah, but we can certainly do that analysis for you and identify what the scale of the change between the ODP and PDP is.
Yes, and obviously we will be interested in hearing from council officers on that later on in the hearing.
Yes. And so
making sure that's not your evidence.
Yes, no, of course not. The proposition I think really is that a significant change has been promulgated by the reporting officers at this very late stage of the process. Not as a result of kind of requiring evidence in accordance with the flipped timetable, providing it well in advance of the hearing for everyone to see. It has, I don't think KO has actually filed evidence for this hearing topic. And so the proposition is not so much about pure legal scope in terms of that submission. We accept that submission was made and that it was detailed and probably did fairly and reasonably raise the prospect of upzoning the heck out of Kerikeri. But what we say is that there is a wider fairness concern.
Yes, I understand that.
Very good.
Anything else?
Thank you. So at 53, really the point we're making is that throughout the PDP process, the initial proposition was that we're not an urban environment. The PDP gives you everything we need. Then the HBA came out and said, "Oh, we've got a shortfall in terms of detached dwellings in the short, medium, long term." And the spatial plan said we're going to solve that with significant greenfield development. And now, because that's not available, the proposal is now to simply intensify and to use that intensification imperative as the way to provide development capacity in the short and medium term. We say the first proposition is wrong. The PDP did not provide sufficient capacity, and I think everyone agrees that now. We say that the second proposition was on the right track, that greenfield development supporting intensification is an appropriate way to achieve housing affordability. And we say that the council's position, as it's continued to swing, has swung too far towards intensification, and it will not achieve, we say, what this plan's objectives are seeking to achieve, or SUD is targeted at. Okay, that's the summary of the party's position. I will, unless you want to ask any questions about that now, I'll hand over to my friend Mr. Marsden to just take you through some of these legal issues briefly, and then we'll return to the core evidence very quickly.
Yeah, I'm just sort of thinking we probably do need to take a more too.
Yes, and
I think maybe this might be because you're switching legal counts out. Maybe we'll take a 20-minute morning tea break now. Everyone in the room is happy, invited to have morning tea with us. I'm sure there's plenty of Kai to go around. What else is all out in the boardroom?
Yes, we'll open up those doors and you can eat on
Feel free
water and we'll open up.
Grab yourself something, a hot drink, and we'll come back at 5 past, or call it 25 past.
Thank you, sir.
Okay, 25 past 11. I am stopping the recording and muting.